Hi, this is Professor David Opterbeck, and welcome to the next lecture in our unit on cybersecurity and computer crimes. In this lecture, we're going to continue our discussion and wrap up our discussion of child pornography, and then we're going to talk about cyber stalking. In our discussion about child pornography, I wanted to show you a little video clip that I found from a defense perspective. This lawyer happens to be in Arizona, but I think the comments that he's making are pretty typical of defense perspectives on the child pornography cases. So we'll show you this, and then we'll come back and have a few other comments about it, and then we'll talk a bit about some developments in New Jersey law.
Hi, I'm David Cantor with the law offices of David Michael Cantor, and welcome to my blog. Today's topic has to do with child pornography. Now, I know most people think, wow, that's something I would never have to worry about, but believe it or not, everybody who has a computer and who shares files does have to worry about this stuff. We have computer forensic experts that are the best if you should happen to fall in the web of FrostWire and LimeWire. In order to be a computer forensics expert, a person has to be certified in NCASE and FTK, pass a written exam, and also take a practical exam, which consists of 60 days to complete. It's quite extensive. Now, when the government is looking to charge people, they will go into your computer and only look for chargeable images. They will never look for exculpatory evidence, and they don't care who was actually at the keyboard. They just assume it was you, and that's not always the case. Basically, your computer contains thousands of cached images on your hard drive, which you got from web browsing in the temporary internet files. What that means, you're online, you're browsing, anything you look at actually gets cached. And you're probably totally unaware that that's on your computer. Now, the media player cache, that happens when you open a Windows media player, and it's created automatically, that being the media player cache. This exists without your knowledge to most people, and it's not actually downloaded by you. It occurs automatically. Incomplete folders. An incomplete folder in your computer contains files that either did not complete loading or that the user canceled during the download. Now, this happens all the time. This is where you're downloading something, it takes too long, and you say, forget it, cancel. Whatever was downloaded goes into your incomplete folder without your knowledge. So this means you could be downloading something you've never even looked at, such as kiddie porn, and it ends up in your computer. These incomplete folders can be shared without your knowledge, and you can be completely unaware of the content. Now, why is it important that it's shared? Well, that's where the second charge of distribution of child pornography comes in. The government looks to charge you with possession and distribution. By the way, in Arizona, each count of possession carries a mandatory minimum 10 years in prison for each image. Each image is stacked on the other one by law. So if you have 5 images, that's 50 years in prison minimum. The maximum is 23 times 5, 115 years in prison. Federal government, they usually offer you 5 years, but if you're convicted, it's 17 to 20 years on a single count of possession and distribution combined. So pretty bad stuff. The government uses a special codex to view files that the average user doesn't have. So even though you may have some of this in your incomplete file and you can't even view it, the government can see it. Now, in regards to LimeWire, LimeWire was shut down about a year ago, and they immediately restarted as FrostWire. Now, this is a file sharing program that a lot of you are probably familiar with, where you can share music, photos, videos, etc. Now, when you open an account, it automatically creates a saved folder, a shared folder, and an incomplete folder. Everything you have defaults automatically to shared and saved. It does this as part of the contract you sign with FrostWire or LimeWire to share your music and your videos. Now, once a user enables LimeWire or FrostWire to send music files directly to your iTunes library, it automatically creates an incomplete folder and it places files in there without your knowledge. So what happens is, for most people, if you have an incomplete file, a user never wants to move or access incomplete files. In fact, you don't even think about them. Yet child porn can automatically default into that file without your knowledge. So if you're automatically downloading somebody's music that you like, you see somebody and they have 10 songs that you really like and you realize, hey, this guy likes the music I will just browse all, Control A, and I'm going to do a mass download. No problem. Well, there is a problem. The problem is, of the 2,000 songs or videos you're downloading into your iTunes account, you don't realize you're not looking at the titles of some of these. And they may have titles in there that say child pornography or something less obvious that is indicative of child porn, but only to the government or people who are purveyors of child porn. So you don't see this. It downloads into your iTunes account, and now you have a video that contains child pornography. The other problem is mislabeled files or malware. So if you download something that says cute kittens and you don't preview it, you just download it. Well, you don't know if it's really cute kittens. It could have child pornography. Now, in order to preview something, you cannot preview what you've downloaded until it completes downloading. Then you can take 10 minutes. You can then start looking at it in 2 seconds, and you can go, oh, I don't want this. Delete. Right? You're fine. Wrong. You're not fine. It's in the incomplete file, even though you tried to delete it, and that folder still exists. You may have watched the first 2 or 3 seconds, and there is no child pornography, and then you really don't know what's on there, and you delete it, but it's still there, and that's the problem. How does the government know it's there? They look what's called hash values. Hash values are basically the number of pixels, and there's a certain hash value for every video or picture that's out there. So there's known child pornography that contains, I don't know, a hash value of 22,572. And the FBI knows that that hash value is child porn. So when you go down and you click on cute kittens without realizing it's child porn, and you say, yeah, I want to download that, and you click onto it, it immediately alerts the government, boom, there's that hash value. Now 2 seconds later you may say, oh, I've got to run, the phone's ringing, you stop the download, you cancel it, and so you never even completed the download, you never even previewed it, but the government's been told you downloaded kitty porn because the hash value matches. That's enough for the government to get a search warrant. Then they go into your house, and then once they're in your computer, unbeknownst to you, you've done a mass download and you have actual child pornography in that computer. That's a huge problem. If you or a loved one are ever charged with child pornography, or if the government has executed a warrant taking your computer away and they haven't quite charged you yet, but you're in what's known as the pre-charge phase, you need to get a lawyer who knows what they're doing. Some other resources, you also need an expert who knows what they're doing. We've found that one of the best experts in the United States actually lives in Arizona. She lives in Tucson. It's Tammy Lears, L-O-E-H-R-S, and she can be found at forensicexpert.net. She is excellent. We used her in a trial in Tucson, and she was fantastic. Also, you might want a trial consultant, and we found that the best one in the nation is Kim Hart, H-A-R-T. Now, Kim Hart started the National Child Abuse Defense Resource Center, and she can be found at falseallegation.org. That's the National Child Abuse Defense Resource Center. As a trial consultant, she can be found at kimhart.com, and she is also excellent. If you or a loved one are charged or a warrant's been executed, you need to get a lawyer who knows what they're doing, and you should consult, at the very least, Kim Hart or Tammy Lears. If you have any other questions, we welcome you to contact us at dmcantor.com, and we'd love to talk to you about this. My feel is I was ecstatic when they shut down LimeWire. I wish they'd shut down FrostWire, but that's what I think. Tell me what you think.
So welcome back, and I think there are a number of interesting things about that clip, and I have to confess that since I've done a lot of work with prosecutors on these kinds of cases, I'm a bit skeptical of some of the claims that are made in this clip. But they are kinds of claims that defense lawyers make, and there are occasional cases in which some of the things that are mentioned in this clip are true, which is that somebody doesn't realize because of a virus or something else like that there's child pornography on their computer, or more often it's someone else in the family, like a teenage child, who's putting the material on the computer and the parent initially is wrongfully accused. Or, in some rare cases, someone is being set up, often in something like a divorce or custody battle, and some materials put on someone's computer. I have to say, though, that at least the prosecutors I've spoken with suggest that in most of the cases, or many of the cases they prosecute, There are thousands and thousands of files on the computer, and it becomes very difficult for someone to argue that it's a mistake or someone else put them there. And further, a lot of these cases involve things like we talked about in our class session last week, which is tracking the person in a chat room or other things like that. Nevertheless, like any other defendant, defendants in child pornography cases are entitled to a defense and have constitutional rights. And so it's important that there are lawyers vigorously advocating on behalf of those defendants. With all that said, I want to show you some recent revisions to New Jersey's child pornography statute. And I gave you the text of the statute, and I mentioned in class last week that I had the opportunity to work on a government working group that I actually helped organize that had some significant input into the way this statute turned out. So one of the things that the statute tried to do was to talk about the age of who a child is, and you'll see here that the age to define a child was moved from 16 years to 18 years, so that anyone under the age of 18 would be considered a child for the purpose of child pornography. This does, as some of you mentioned in class, raise an interesting tension between who is a child for child pornography and the age of consent for children engaging in sexual, or young people engaging in sexual activity. Another aspect of the changes that were made to the statute were to increase the level of crime for certain activities and to increase the possible penalties. And the reason for this, really, talking with the prosecutors on the working group, was that judges, most cases of this sort don't go to trial. Most of them plead out, and judges had been reluctant to kind of put pressure on defense counsel to plead these cases out in a way that would involve any kind of jail time for the defendant. And judges, from the prosecutors I spoke with, at least some judges in the state courts, seemed convinced that it could be possible that some of this activity was a mistake, or some of it wasn't quite as serious. Maybe the person dabbled in it once or twice and were reluctant to impose jail time, and it made it difficult to plead those cases out in some ways. So the penalties were increased in part so that at the plea bargain stage there's less of an opportunity to argue that a particular defendant who really is engaged in this activity shouldn't have jail time. And that's what some of these kind of bump up provisions are designed to do. You'll see another one here, second degree crime. Now, a really interesting aspect, and I think a potentially controversial aspect of what we did with the New Jersey statute, was concerning the question of possession with intent to distribute. Because if you possess the file, it's one kind of crime. If you possess with intent to distribute, it's another kind of crime and also another degree of crime. And the issue really arose where people were raising a defense that, well, I have a file sharing program like Kazaa or LimeWire, and by default the option to share files is enabled when you download those programs. And so yes, I had some child pornography on my hard drive, but I never intended to share it, and I didn't even know that the sharing button was enabled in Kazaa or LimeWire or whatever peer-to-peer program I had. Well, the statute now says that any use of a file sharing program to knowingly store or maintain an item which is designated as available for copying constitutes an intent to distribute. And notice these various provisions here that the state does not have to prove that any particular item had actually been searched. It's no defense that to say that, well, I didn't know the button was on. The state is not even required to prove that the defendant knew that this particular file was in the sharing folder. Simply the act of having a peer-to-peer piece of peer-to-peer software with sharing enabled and contraband child pornography in a folder that could be shared constitutes intent to distribute, constitutes a more serious crime. It's the prosecutors that I worked with thought this was really important. You can see how it potentially could be controversial. There also were provisions added to ensure that a person convicted of a crime, certain kinds of these crimes, have to serve a certain portion of their sentence. And again, part of the reason for this is so that in the process of plea bargaining, it's not as easy for defense counsel to argue that there shouldn't be jail time. In effect, for certain kinds of crimes, there's going to have to be some jail time. Another important part of this was the definition of how many items constitute what level of crime. And the statute still is key to the fact that if you have a certain number of files, that will influence what kind of crime, what degree of crime it is. And you'll see here that the degree of crime was bumped up, so just having 100 or more items is now a third degree crime instead of a fourth degree crime. Why is that important? It increases the potential penalty, and 100 items might sound like a lot, but the fact is that 100 items is really pretty small, and it is not difficult at all to acquire 100 photographs, as you know from just ordinary, legitimate kinds of photographs that you might have. So more often than not, if someone is caught, it's going to be 100, at least 100 or more items. Another aspect was to require parole supervision for life. Again, the prosecutors I spoke with felt this was important because there's a high degree of recidivism, and of course because the crimes target children and victimize children. So, and this allows the government to monitor someone's computer activity. Note also that the statute specifically requires the disclosure of all passwords, including social media passwords. And this was, again, important to law enforcement, that they could monitor someone who has been convicted for life as part of the terms of their parole, monitor their social media. Now again, I recognize this could be controversial, and there are many concerns that people raise about laws like this going all the way back to Megan's Law and so on. And there are some legitimate kind of civil liberties concerns, but nevertheless, ultimately the legislature and the governor thought that it was important enough, the issue of protecting children was important enough that this provision should be included. So here's just a chart of the current New Jersey sentencing guidelines. I'll just leave it up on the screen for a minute. I won't try to read the whole thing, but you can see what the potential prison terms are, and you can see now that these kind of crimes are almost certainly going to carry some kind of mandatory prison term that is actually going to have to be carried out, and it's going to make it much more difficult for these cases to plead out without having the person being removed from society for at least some period of time. So the last piece of child pornography law in New Jersey that I wanted us to look at is the question of virtual child pornography. And recall last week that we looked at the federal law surrounding virtual child pornography, and there is an important case in New Jersey in the appellate division, State versus May, in 2003 that addresses the same issue. So in State versus May, the defendant is convicted of possession and distribution of child pornography, but claims the images were of dolls, and claims they were computer drawn, and so on, and were not actual children. Under cross-examination, the detective who examined the defendant's hard drive, as well as an expert retained by the state, were equivocal about whether the images could have been morphed images of adults or otherwise manipulated images in which no actual children were involved. And in effect, I think if you read the case, you can see that these, both the detective and the expert, were not really well prepared for this line of questioning. The defendant himself testified and said he believed that the images, in fact, were morphed images of adults, and they weren't actually images of children, and therefore there would be no violation of the child pornography statute. So the court noted that in Ashcroft, the U.S. Supreme Court had said that a child pornography law would be overbroad if it criminalizes simply virtual images, but also noted that Ashcroft didn't quite address the issue of morphed images. And the appellate division reverses and remands for retrial, and said that the prosecution on retrial must prove beyond a reasonable doubt that the images in fact were of real children and not of virtual children. So how would you do that? And again, at this time the statute was that for child pornography was that someone was a child if they were under 16. So direct proof is not required. You don't have to produce the actual children, which in almost every case would be impossible. The jury can infer from the images whether the children were below 16. You could do that possibly just based on outward appearance alone. It could be basically based on common knowledge. It could be based on some kind of expert opinion. Obviously, if it's a photograph of a baby, you can infer that it's below 16. As they get closer to being 16 years old, you might require some expert testimony. And there are various ways in which you can present expert testimony that would be proof of age. I give you here a citation of a U.S. District Court case that has sort of a good litany of ways in which you can do that. But there are experts who can look at sort of the development of the sex organs and so on, even in a photograph, to give an opinion about whether the person depicted, in fact, is an adult who was just, shaved to look like a child, or in fact is at a state of development in which the person is likely an adolescent, things like that. So the court notes that the trial court must examine each of the images, must make an assessment of each image. The trial court serves this gatekeeping function to determine which of the images have to go to the jury, and the jury has to be instructed that the state, in fact, bears the burden of proof. So that's our kind of very brief discussion. There are other cases we could talk about, but we've talked about a lot of cases already on the law of child pornography, both at the federal level and in New Jersey, and of course in every other state in the Union. There are statutes and cases dealing with similar issues. So let's now turn to the question of cyberstalking. And to set up this discussion, I want to show you a brief video clip of ways in which someone could be engaged in cyberstalking. You'll notice in this clip someone named Tim Ryan. He's a former FBI agent, used to run the FBI's cyber unit in Newark. He's a friend of mine, and he happens to appear in this video. So I'll show you this video, and then we'll come back and talk about it.
Symphony Diaz?
Yeah.
No way. Jason? We met at the Wranglers hockey game. You were with Brad? Your boyfriend, right?
Yeah.
How do I know Symphony Diaz? I don't. But thanks to Facebook and Foursquare, Crime Watch Daily has uncovered intimate details of her life. A realization that quickly freaks her out.
I'm gonna go to the bathroom.
I'm Jason Matera with Crime Watch Daily.
Hi.
And here's the really scary part. As soon as you check in on social media and pinpoint your exact location, you turn into an instant target for cyberstalkers.
That was creepy. I'm like shaking right now. Oh my gosh, that scared me so bad.
We set up stings in Las Vegas and New York City, and over the course of 2 days, watch for people checking in on social media at both of the Buca de Beppo restaurants.
They're showing their family members right here.
Tim Ryan, a former FBI agent and cybersecurity expert, then went to work probing their private information. It took him no time to find out Symphony likely lives alone in an apartment and watches TV by herself at night.
Does that freak you out?
Freaks me out a lot. Like that's not something I like.
It gets worse.
Angela Alfiones?
Yes,
You worked at Wynn?
I did.
Jason, you remember me?
No, but I worked with so many people over there.
I wonder if Angela's son, who's away at college, knows as much about his mom's past as I do.
Does Forrest know what you used to do?
Yeah, Forrest wants to get into IT.
Does Forrest know about your time
My
as
time.
a stripper? Or
As
applying
a-
for a stripper?
I don't
You know
remember
about that
applying for a
profile?
stripper.
No?
What profile?
You have any tattoos besides the one on your chest and your hip?
No.
Just those two?
Uh-huh.
Did you ever work as a stripper?
No.
No, then what's the
No.
stripper profile for?
What stripper profile? That's what I'm talking about.
You don't know the stripper profile?
No.
Oh, man.
News to me.
Look, I got it right here too. Right here.
Oh yeah, somebody stole my. That's an old picture.
Yeah.
I was 30 in that picture. That's
You were-
7 years ago.
You were 30, so did you ever get the stripper job?
I didn't do a stripper job.
So they just uploaded this?
Somebody stole that. That's yeah. What's this for? Is there any way you can email me this? Waitress.
So somebody took your pictures from the internet,
They had to.
posted it on a
Yeah.
on a strip club job site, and they even knew about the tattoos you have. I even knew that Forrest was your son going to Central Oregon
That
Community
is so
College.
scary. What site is that? 'Cause
Jason Matera with Crime Watch Daily,
Oh, nice to
and
meet
you've
you.
just been cyberstalked.
Oh my gosh. Well, apparently I've been caught.
The fact that we were able to do that so effortlessly, will it make you reconsider what you tag as public information on Facebook?
Yes, actually, you have no idea the changes that are about to occur as soon as I leave here. Yeah, absolutely.
And here's a shocking stat. 87% of all cyber stalkings target college-age women like Molly.
Molly,
Yes?
Jason, we met Springfield.
She's a young actress from Oklahoma, low-hanging fruit for a digital deviant.
Are you nervous being at home alone while Dan is gone?
I mean, you know, it's, are these, yeah, no, I'm okay. I'm okay with that.
You curious how I know all of this about you?
Yeah,
Well, I'll tell you what. I'm Jason Matera,
Okay.
Crime Watch Daily,
okay.
and you've been cyberstalked.
Luckily for Molly, Tim Ryan has some helpful tips to avoid a stalker's trap.
Well, you saw Jason do right there. That's exactly what a stalker is going to do. So I know you're an actress. You have to be on social media, but you probably don't want to tell everybody everything. So creating little groups, creating lists of people that can see stuff and other people that can't, that's pretty important. Right? You don't want that guy, the creepy guy who lives across the street or downstairs, to know when Dan's gone and you're home alone for a period of time.
With 3 million cases of cyber stalking reported every year, it's important to know how to limit your exposure, especially if you're one of those who likes to bare their souls on the web.
Jason. Share the same dentist. Dr. Pope. Oh,
With a quick glance at David's social media pages, Tim and I uncovered rants about his ex-wife and other posts of a highly personal nature.
Are you concerned with putting a lot of private information out there to the public, that someone with bad motives can use that against you in any way?
No, you know, I'm a very spiritual guy and I feel like God will protect me.
For those without a celestial firewall, there's Tim Ryan.
Here's the problem. About $70 million a year is stolen by criminals in a thing called romance fraud. So the criminals, usually from overseas, they're looking for people who've experienced loss, and you've experienced some pretty significant loss. Problem is, they're not going to appear as Jason. They're going to come at you as a girl, they're going to come at you as an attractive woman, and then they're going to ask you to do things for them.
what do you think
No,
about that?
I know, that's true. I have a weakness for women.
Tim's takeaways to cut your exposure to cyber stalking? Remember that the internet never forgets. What you post today will live on forever. Use privacy filters to restrict information to your closest friends and family. Avoid disclosing your location. The world doesn't need to know your home is empty. Finally, be cautious about sharing your vulnerabilities. Because the next time a stranger comes up to you,
Alexander?
he might not be from Crime Watch Daily.
So welcome back, and it should be no surprise to all of us that given the extent of all of our online lives, if someone wants to track us down and someone wants to harass us online, they probably can do it. Now, you know, Tim Ryan in that video, being the good consultant that he is trying to tell us to keep various things segregated in our online lives. As we talked a little bit in class last week about this, that can be really difficult to do. In some ways, maybe it can be impractical to do, and in some ways, maybe our social norms suggest that nowadays suggest that we don't need to do it to such an extent. But we do need to be aware that someone could come after us, and these kinds of things do happen, and they do happen regularly. And you see that in the cases that we've looked at. You can also see that in some news reports, and I'll put some links up on the website to some other news reports that show you some other examples, if you want to watch them, of cyber bullying, cyber harassment, cyber stalking. So how does the law respond to this? We have looked in some detail now at the Computer Fraud and Abuse Act, and you should notice that the Computer Fraud and Abuse Act doesn't really deal with what we're calling cyber stalking. Now, it's possible that some portions of the Computer Fraud and Abuse Act could be implicated by some of the kinds of activities that we call cyber stalking. So certainly if someone hacks into someone else's computer in order to get information or manipulate information to engage in harassment, that also could be a violation of the Computer Fraud and Abuse Act. Or the extortion provision of the CFAA could be implicated, although it's not really the typical case. That's typically for some kind of hold up for financial gain. Fraud aspects of the CFAA could be implicated as well, but generally the CFAA is not designed to go after the kinds of harassment and stalking and threats that we're trying to address in this lecture and next week as well. So we're going to talk a little bit about federal law today, and we'll talk a little bit more about state law next week. So the federal statutes that exist, there are a number of statutes that beyond the CFAA that potentially could be applied to the kind of conduct that we're talking about today. One of them is 47 U.S.C. 223, which is titled Obscene or Harassing Telephone Calls, and as you might imagine, it was originally created in the telephone age, but it's broad enough because it talks about the use of a telecommunications device to cover some of these kinds of activities. So this is one possibility, and you'll see the kinds of transmissions that could be implicated. A proposal image communication which is obscene or child pornography with the intent to annoy, abuse, threaten, or harass. Now you should be thinking, as you look at these statutes, that both this week and next week, we'll talk about it a little bit this week and some more next week, how broad can this go and still be constitutional? Think about, for example, the use of any telecommunications device to annoy somebody. How often does that happen, let's say, on Facebook? If I put a post up, a sarcastic post up about Donald Trump, because I know my brother-in-law likes Donald Trump, and I know this will annoy him, am I violating federal law? I suppose in one sense technically I could be, but I highly doubt that ought to be considered a violation of federal law. So think about, and obviously that kind of conduct isn't likely to get prosecuted, but think about where the lines are. And it can be hard, I think, to draw these lines and to figure out where we ought to draw them. Another statute that often gets applied in these kinds of cases is 18 U.S.C. 875C. And again, this is a statute that really relates originally to kind of telephone days, and you'll see that it's kind of revolves around kidnapping, threat of injury, that sort of thing, but it also applies because it's, again, any transmission in interstate commerce of any communication. It also can apply, this threat statute also can apply online. So we'll look at a few cases that deal with that. The primary statute, in one sense, today now is what's formally titled the Violence Against Women Act, but also has these provisions that are called the Federal Cyber Stalking Law, and it's found in 18 U.S.C. 2261, capital A. So in subsection 2 of capital A here, you see this provision, and I'm showing you this language, and then I'm going to show you how this statute was amended in 2006 specifically to address cyber issues. And then I'll show you again how the statute was amended in 2013 to try and further address cyber issues. So you'll see here intent to kill, injure, or harass, or intent to place under surveillance with the intent to kill, injure, harass, or intimidate, or with the intent to place a person in another state in reasonable fear of the death of, serious bodily injury to that person or a member of their immediate family, spouse, or intimate partner using the mail, or any facility of interstate or foreign commerce, or any interactive computer service. So you see that those definitions that include interactive computer service or any facility of interstate or foreign commerce, which certainly most ISPs are going to be, engaging in these kind of conducts can be a violation of this statute. Notice the requirement that the course of conduct actually cause substantial emotional distress to that person in reasonable fear of death or serious bodily injury to that person or an immediate family member, and so on. So there is both an intent requirement and an effect requirement. An intent to injure, kill, harass, or place under surveillance with injure, kill, harass, and the effect of causing substantial emotional distress, even if the person isn't actually, killed or physically injured. Now, where was this statute amended in 2006? It was first amended to include this word harass. It had only included, it was sort of a traditional stalking statute, and it was being tried to brought into the digital age to include things beyond physical stalking to kill somebody. So harassment was included there, or the intent simply to cause substantial emotional distress. So the idea here is this kind of bullying and harassment online. And the interactive computer service was added. So to try and be clear that the cyber aspect of this is specifically covered, and the fact that it would cause substantial emotional distress, not simply other kinds of injury. So all these things were added to make this a statute that is dealing specifically with cyber stalking. Now let's talk a little bit about the 2013 amendments, and I'm going to pull these up on the screen from Westlaw so that we can talk about those.
So here is the current version of the statute, which includes the 2013 amendments. And if you look at subsection 2, you'll see some changes. The first set of changes involves the kinds of facilities that if one uses them would trigger the statute. So uses the mail, any interactive computer service, we've seen that before, and or any electronic communication service or electronic communication system of interstate commerce. And so these two categories, I think, are intended to capture email, social media messaging platforms, and things of that nature. Probably interactive computer service, facility of interstate or foreign commerce would have included those already, but these things are added to make clear that those sorts of uses are covered. Notice then in subsections A and B, the fear of death or serious bodily injury is then broken out from the substantial emotional distress. And notice what could be potentially a significant change in sub B there, which is causes, attempts to cause, or would be reasonably expected to cause substantial emotional distress. Now, in a moment, we'll talk about the Conlon case, which is one case upholding the constitutionality of this provision against a claim that it's overly vague and that it unduly impinges on free speech. And there are a number of challenges like that. There's one in a district court in Maryland that in fact found the statute, the 2006 version of the statute, unconstitutional. But the Conlon case upholds the constitutionality of the statute. But notice the reasoning, and a key piece of the reasoning was that the court said it's not only an intent to speak in a certain way that might be offensive, but also the effect of causing substantial emotional distress. When you add the effect to the intent, the Conlon court said, you can conclude that the statute is constitutional. Now, I'm not sure that reasoning is sound, at least under this version of the statute, because in subsection B, it appears to me that it would not necessarily have to have the effect. It simply could be reasonably expected to cause substantial emotional distress, even if the speech doesn't actually cause substantial emotional distress. So there perhaps is a lingering question about the constitutionality of the statute, and I think that's one of the kind of underlying legal and policy issues you ought to be thinking about as we look at some of these cases that deal with cyber stalking and harassment, and then next week when we look at bullying and other similar statutes, we have a difficulty saying that speech that is offensive should be illegal simply because it's offensive. Because after all, the First Amendment, if it protects anything, protects speech that some people find offensive. And yet, the law wants to have some limits when it comes to these activities that we would call stalking or perhaps bullying and harassment. So keep those things in mind. And now we'll take a look at the Conlon case and some other cases.
Okay, so now let's look at some case law that has been decided under a number of these statutes. And first we're going to look at the Conlon case, which was decided just this year under the cyber stalking statute. So factually, you'll see defendant and the victim had dated as teenagers but had no further contact as adults. At some point, the victim, and it's not clear in the opinion how or why, is on a national news program, and the defendant sees them and rekindles something or other in the defendant. And so the defendant tries to restart this romantic relationship. The victim makes clear that she doesn't want anything to do with this, and that triggers then the defendant engaging in this cyber harassment campaign. And you can see in the opinion the various kinds of messages and things that the defendant does. The court describes it as an escalating campaign involving email, text, social media, telephone, face-to-face, including the victim, her family, her work colleagues, her church members, and various other people. So there are two issues in the case. The first issue was the evidence sufficient to show the intent to kill, injure, harass, or intimidate? And the court answers yes. And I think this was a relatively easy one, but the point is what kind of evidence do you need to prove that intent? And you can use circumstantial evidence, and the circumstantial evidence can include simply what the court describes as the increasingly ominous tone and content of the activity. And I think it's pretty typical if you look at some of these cases, this pattern that it starts out maybe even innocuously, and then it steps up to something that's kind of mildly disturbing, and then it becomes something really intense. And the court says that kind of stepping up can provide the circumstantial evidence of the intent to, in fact, cause some kind of harm, harass, intimidate, or even physical harm. Issue two is this question of constitutionality. And so the defendant argues that the statute is unconstitutionally vague, because after all, what does harass mean? What does intimidate mean? And the court says no, it is not unconstitutionally vague. Harass and intimidate, the court says, are readily understandable common terms. The statute doesn't have to specifically define what those mean. They're not obscure at all. And then, I think very interestingly, kind of from the legal perspective, the statute doesn't criminalize otherwise lawful speech. And if you look at I gave you a redacted version of the opinion. If you look at the original opinion, it talks about some other case law involving statutes that were trying to criminalize wearing the regalia of the Ku Klux Klan, so wearing the white hood and that kind of thing, simply wearing that. And in those cases, there's case law saying you can't criminalize just that, because it could be lawful to wear that. You might wear that costume in a play, you might wear it to make some other kind of point, you might wear it as a Halloween costume. It would be kind of a horrible thing to do, but somebody might. And though that may be in bad taste, shouldn't necessarily be illegal because it's free speech. But here, the court says because there's both intent and effect, you have to have the intent and also cause the fear. That does trigger liability. So the next case that we want to look at is the Infante case. So the Infante case, the defendant meets with the victim on an overseas study trip, a kind of college trip. Tries to connect with her on Facebook, sends her emails, leaves her phone messages, leaves her flowers, and even goes so far as to visit the campus in Rochester where the victim is going to school and going to her classes and trying to find her. So the defendant's story, of course, is, well, I'm in love with this person. I'm infatuated with this person. I think we're destined to be together, and she just doesn't realize it yet, and I've got to convince her. And you can sort of see in the defendant's mind there's some kind of romantic comedy playing out, and in the victim's mind there's sort of a horror movie playing out. So the issue that arises under 2261A, and this is actually under Part 1 of the statute because he's actually traveling, and it's also a prior version of the statute, but the issue is still, is there an intent to harass? And so here the court says, and talks about, can the intent to harass be inferred from what actually happened, or must you have to prove the subjective intent to harass? And this court says you in fact have to prove that subjective intent. It's not something that can just be inferred, would a reasonable person think there's an intent to harass, but you have to show that in fact the defendant had the subjective intent to harass. Now, that's not inconsistent with saying you can use circumstantial evidence. You can still use circumstantial evidence to prove the subjective intent, but it's not would a reasonable person conclude that there was this intent, but in fact does the evidence show that the defendant had this intent. And here the court says, no, there was not enough evidence to show that subjective intent to harass. He gave some statements to the FBI, and those did not show an intent to harass, and the court here said that, in fact, really all it was this kind of misguided romantic hope that he could renew the relationship. Now, I think when you put these two cases together, the Conlon case and the Infante case, it's very interesting to see that contrast. Now, if you read the Conlon case, you can see the conduct there. He was sending pornographic, sexually explicit pictures. He was engaging her church members even after she told him to stop multiple times. And the conduct seems to be more ominous, perhaps, than the conduct in the Infante case. But on the other hand, if from the perspective of the person who has to endure some of this, the conduct of Infante could be pretty frightening. And so where do you draw those lines? Where do you draw the line between something that is socially inappropriate, perhaps, and perhaps disturbing, but on the other hand, something that is should be unlawful and considered a crime? And I think we all can see that there are places at which we can make those judgments probably readily, easily. There are places at which it can be fuzzy and maybe difficult to make those judgments, certainly in the context of a criminal statute. So the next case we'll look at is the Jordan case. So, this case, I think, illustrates, again, the kind of conduct and the kind of escalation that can happen. So there's, and this is often, unfortunately, the kind of thing that you see in these cases. There is initially a legitimate, so to speak, relationship. There's a dating relationship, maybe even there's a marriage relationship, and then at some point that relationship falls apart. And it's not uncommon, I think, at least from what I've seen in these kinds of cases, that there is someone, unfortunately, with an abusive personality, and that abuse could be physical abuse, and then it could be physical abuse that spills over into the virtual world. So here, the abuse is bad enough that Thanal, the victim, kind of tries to get out of the state. Jordan continually calls her, And then he does something that's, again, characteristic of a lot of these kinds of cases. He starts posting false information about Thanal. He, posts an ad for prostitution services on Craigslist, and she gets calls on that ad, and does all these kinds of things. And this is a classic sort of pattern. He registers a domain name and writes about some of this stuff. He even tries to contact the British embassy when the victim's aunt is over in England. Continues to send fake documents, fabricated things all around the world. And so you can see this kind of pattern of escalating conduct. And so again, the issue is there sufficient evidence to show that there's a subjective intent to harass? And I think in this case, it's relatively easy for the court to say that, yes, in fact, there was abundant evidence, and it showed pretty clearly that his conduct was calculated, was elaborate, and even if he denies that subjective intent, the circumstantial evidence shows that that intent existed. So our next case is the Rose case, and again, I think the case gives you a kind of typical factual scenario. They meet, their relationship becomes romantic, it's at a distance online. Fisher tells Rose that she is a widow. They plan to meet, but then Fisher changes her mind. Rose decides, I'm going to go meet Fisher anyway, and finds out, lo and behold, Fisher is married. So Rose begins then harassing, sending threatening and vulgar emails, and I think the thing that's really frightening about this case is posts pictures of Fisher's children to websites that are used to solicit sexual activity. Remember last week I mentioned there are a variety of sites that involve things like parents pimping their children and other horrible things like that. So you can see, again, how this conduct escalates. The specific legal issue in the case is whether this conduct warrants sentencing enhancements under the federal sentencing guidelines. Don't worry about the details of the sentencing guidelines. Just see that in this case, the court says, yes, this conduct is severe enough. And I think it's really the posting of the photos of the children that warrants sentencing enhancements. Our next case is this Oneida case. So this case is interesting because of its factual context, and I think actually this case is difficult because of its factual context. So if you remember the Virginia Tech shooting, one of the large, terrible campus shootings in the United States, so this guy Oneida, who's a student at Penn State, posts some statements on his MySpace account. I guess MySpace was sort of still a thing when he did this, but he's lauding the Virginia Tech shootings and the Virginia Tech shooter. He's venting some misplaced rage or whatever it is. And the issue is here, under 875C, the threat statute, does this constitute a threat that can be prosecuted? And if it does constitute a threat, were these threats transmitted? Or was this more like, is the MySpace page more like a kind of diary entry where, again, the person might be disturbed or might have some issues or might just be working out some anger or whatever he's doing, but it wouldn't necessarily be a crime. And here the court said no, a reasonable jury could find that this reflects a serious intent to inflict bodily harm. The threat doesn't have to be imminent. It can be something that may occur in the future. And the court said postings on MySpace are necessarily transmitted in interstate commerce. So at least for the purpose of the indictment surviving, the court said this survives. So I think this case is a little bit difficult. I mean, we do have to be really sensitive, obviously, and we see even this past week with the events in France how sensitive we have to be about these kinds of terrorist activities or just a crazy person or a student. We know how difficult all these issues are. But the question is, how do we intervene in those circumstances? Is it the law? Is it the criminal law that intervenes? Is it other kinds of social services? Is it a mixture of two? How do we do that? And how do you write a statute, and how do courts interpret statutes that do that? These are difficult questions. And our next case is the Al-Kabaz case. So this case, I think there's a number of cases in this set that are disturbing. This case to me is one of the most disturbing cases in this whole set of harassment cases. So here, this guy Alcabaz, his actual name seems to be Baker, is trading messages over the internet with this guy Gonda, and they just know each other from these chat groups that they're both on. And what they're on is groups in which people write stories depicting really hideous, violent acts, including rape, torture, and murder of young girls. So they're trading stories. They're trading kind of novelistic stories. But you see in the opinion how there's this kind of back and forth about, we need to really meet up and actually do this. And of course the defense is going to be, well, that was all kind of role play. It was all part of the being in the role of this author. We didn't really want to do anything. And so part of the issue, are these really true threats? And the court goes into some detail about what the mens rea and actus rea requirements are. So what is the mental state and what is the action that is required to violate this? So this court says the mens rea requirement is proof that a reasonable person would have taken these threats as a serious expression of to inflict bodily harm. And there is a note in the case that some courts, a minority of courts, require a specific intent to harm a particular person. So clearly here, Alcabaz's stories and his statements were kind of generalized. We want to do this to somebody. It wasn't, there's Mary Jane, let's go get her. So some courts say it has to be, there's Mary Jane, let's go get her. Other courts, including this one, is any proof that a reasonable person would take this as some kind of serious expression of intent to hurt somebody, some real person, but not an identifiable person necessarily. So what is the actus reus? That's the mental state. What is the action that is required? So this court kind of goes through some precedent on this, and the basic standard is, well, do you communicate this threat generally? Do you have to communicate it to some specific individual, or can you communicate it to someone with some connection to this specific individual? And this court says the kind of some connection standard is too vague, and what a threat actually is an effort to achieve some kind of goal. And even if it's innocuous, even if it's a prank, it still could be a threat, but it has to have some action that involves a threatened individual and an act to act on that. So this court says the standard is whether a reasonable person would take it as a statement of serious expression of an intent to inflict bodily harm, the mens rea, and then would perceive the expression as being communicated to effect some change or achieve some goal, a specific goal, through the intimidation, the actus reus. So it's not just kind of sitting out there in the ether, but there's a goal behind it. The court notes that the purpose of the threat statute isn't so much to regulate speech, which would raise constitutional issues, but is to protect the recipient of the threat, and particularly to protect the sense of well-being of the recipient of the threat. So we say that everyone has a right to free speech, but if your speech is threatening and is seriously impinging on someone else's well-being, you're impinging in a sense on their liberty, and so we find a space in there in which we can, the law can step in and regulate that conduct. And the court says if the communication is not transmitted, then it can't be a threat. And here the court said these communications between Baker and Gonda, as disturbing as they are, can't be threats because they're only communicated between the two of them. They're not communicated to any potential actual target, whether it's a recognized individual or just kind of generally to the public. They weren't made public. They were, according to the majority opinion, private communications. Now there is a dissent in the case, and the dissent has a lengthy section. If you're really interested in this and you can stomach it, you can get the case off of Westlaw and read the lengthy quote from one of Baker's stories. I've put it in enough detail in the redacted version so you get a sense of what's going on. I left a lot of it out because it really is disgusting and horrifying. So the stories were not just kind of general. I mean, they were really explicit, horrifying stories. So the dissent says, look, if you look at these actual stories and you look at what the statute actually criminalizes, and the dissent says, really what the statute is doing is setting up an objective standard that a reasonable person would perceive a threat. In that case, the indictment should not have been dismissed. So I think the two opinions in this case leave us with a tension that we mentioned at the beginning of this section on cyberstalking, which is that there are cases in which there's a pretty clear communication to an identifiable person, and it escalates, and you can say, yes, that falls in a category in which the law should step in. There are cases in which it doesn't go that far, it doesn't escalate, it's relatively innocuous, it's just somebody's hitting on someone at a club, they're a little persistent, eventually they go away. It's maybe annoying, but the law shouldn't step in. There are cases in between where there's a fuzzy area. And then there are also cases in which there's some speech that that most of us find really disgusting, but that maybe the law can't criminalize, or maybe the law can criminalize. And the question is, where and when and how can the law step in? So that's the end of the lecture for this week. We'll talk about this a bit more in class on Thursday, and then we'll pick it up again in our lecture for next week.